State of Orissa vs. Bahadur Thapa on 9th November 1959. This is an appeal by the state of Orissa against an order of acquittal passed by the Sessions Judge of Mayurbhanj in a case under sections 302, 324 and 326 IPC instituted against the respondent, a Nepali named Bahadur Thapa. In village Rasgovindpur in Balasore district, there is an abandoned aerodrome in which was collected a large quantity of valuable aeroscrap. Jagat Bandhu Chatterjee of the firm Chatterjee Brothers, Calcutta, came to Rasgovindpur accompanied by a Nepali servant named Ram Bahadur Thapa, sometime in April 1958, for the purpose of purchasing the said aeroscrap. He and his Nepali servant stayed in the house of Krishna Chandra, who was keeping a tea stall in village Rasgovindpur. All round the aerodrome, there are Adivasi villages, inhabited mostly by Santals and Majhis. These persons have strong beliefs in ghosts, and the abandoned aerodrome earned the notoriety in that area as being infested with ghosts. There are several footpaths cutting across this aerodrome, leading from one village to another, but on account of their fear of ghosts, the Adivasis would not ordinarily venture out at night alone along those paths. Jagat Bandhu and his Nepal servant were anxious to see the ghosts, hence, at about midnight, they persuaded Krishna Chandra to accompany them to see the ghosts. While passing through camp number 4, they noticed a flickering light at a distance of about 400 cubits from the pathway. There was a strong wind blowing, and the movement of the light in the breeze irritated them an impression that it was not ordinary light but the will of the wisp. They also found some apparitions moving around the flickering light. They thought that some ghosts were dancing around the light, and they ran towards the place. The Nepali servant reached first with his kurki. He began to attack the ghost indiscriminately. Krishna Chandra arrived there after some time, but the respondent did not notice him, and one of his kurki blows caused severe injury to Krishna Chandra, who screamed aloud saying that the Nepali had injured him. In the meantime, other injured persons also raised a cry of distress, and then the respondent stopped attacking the people and came back to his senses. The consequence of the indiscriminate attack by the respondent with his kurki, one woman named Gelhi Majhiani was killed, and other 2 females named Ganga and Soundri were grievously injured. In addition, Krishna Chandra, as stated above, was injured too. On the aforesaid facts, the respondent was charged under Section 302 IPC for the murder of Gelhi Majhiani, under Section 326 for causing grievous hurt to Ganga and Soundri, and under 324 for having caused hurt to Krishna Chandra. The learned Sessions Judge held that the respondent committed the said facts under a bona fide mistake of fact, thinking that he was attacking ghosts and not human beings. Hence, he acquitted him for relying on Section 79 IPC. It is not the prosecution case that the respondent had either the necessary criminal intention or the knowledge, and it was fairly conceded by the Learning Standard Council that when the respondent attacked his victims, he thought he was attacking ghosts and not human beings. But it was urged that the respondent did not act with due care and attention, and that consequently he should be held guilty under Section 304 for having caused the death of Gelhi Majhiani, and Section 336 for having caused hurt to other persons. Before discussing the true importance of Section 79 and its applicability to the facts in this case, it is necessary to come to clear findings on facts of the circumstances. The circumstances under which the respondent behaved the way he did. It is true that Jagat Bandhu Chatterjee is the master of the respondent and might have some sympathy for him, but his evidence was consistent. From the evidence of Jagat Bandhu and those portions of evidence from Krishna, the following facts clearly emerge. The respondent and his master Jagat Bandhu Chatterjee were strangers to the locality, having come there only 6 months before the incident. The aerodrome was reputed to be infested by ghosts. The whole party was thus obsessed with the idea that there were ghosts in the aerodrome and that they might be seen at that hour. They saw at a distance a flickering light which, on account of the breeze, was then blowing, appeared like will o' the wisp. There was also some figures moving around the light, and Krishna Chandra pointed out, shouting, "Here are the ghosts." Thereupon, without thinking even for a moment, the respondent rushed towards the alleged ghosts, armed with his kurki, by shortest cut and began attacking them indiscriminately. Krishna Chandra followed him by a regular path, but he also sustained injuries from the kurki blows. Then he cried aloud, and this brought the Nepali to his senses. Jagat Bandhu Chatterjee further admitted that the respondent Nepali was a firm believer in ghosts and stated that when the latter rushed towards the flickering light, he had no doubt in his mind that he was charging ghosts and not human beings. The benefit of Section 79 IPC is available to a person by the reason of mistake of fact in good faith, believes himself to be justified by law in doing an act. In the view of clear evidence of Jagat Bandhu Chatterjee, to the effect that the respondent thought he was attacking ghosts, he would be entitled to the benefit of that section, unless from the facts and circumstances established in the case, it can be reasonably held that he did not act in good faith. Good faith requires due care and attention, but there can be no general standard of care and attention applicable to all persons under all circumstances. The standard of care and caution must be judged according to the capacity and intelligence of a person whose conduct is in question. It is only to be expected that the honest conclusion of a calm and philosophical mind may differ very largely from the honest conclusions of a person excited by a sectarian zeal and untrained to the habits of reasoning. The question of good faith must be considered with the reference to position of the accused and the circumstances under which he acts. The law does not expect the same standard of care and attention from all persons regardless of the position they occupy. The respondent is a Nepali servant who is a newcomer to a place. He was a firm believer in ghosts. The aerodrome had acquired a notoriety as being haunted by ghosts on Tuesdays and Saturdays, and this created him almost a certainty that the ghost would be there at about midnight on that date. The party also left Rasgovindpur for the purpose of seeing ghosts. Neither the respondent's master nor his landlord made any effort to remove this impression from his mind. On the other hand, they themselves confirmed that they offered to go with him for the purpose of seeing the ghosts. Considering the status and intellectual attainment of this respondent and the place and time and the circumstances, I do not think it can be said that he acted without due. I do not think it can be said that he acted without due care and attention. When even persons with higher standard of intellectual, like Jagat Bandhu Chatterjee, Krishna Chandra, thought that there were ghosts around the flickering light, find when neither of them dissuaded the Nepali from going there, and when on the other hand Krishna Chandra cried out, pointing out that it was a ghost, it would not be proper to expect that Nepali should have paused and examined carefully whether the persons moving around the figures were human beings or not. His immediate reaction to such a situation was to rush at what he believed to be ghosts. The High Court held that the assailant were was protected by Section 79 IPC because from the circumstances under which the apparition appeared before him, in his predisposition, it would be reasonably inferred that he believed in good faith that he was attacking a ghost and not a human being. The learned sessions judge was therefore right in acquitting the appellant. The order acquittal is confirmed and thus appeal is dismissed. Thank you.